I'm a clinical fellow in the mediation clinic for families here at UB, and I'll be moderating this panel. This panel embodies diverse areas of scholarship that share an overarching theme of the health consequences of gendered roles. Gendered roles influence public discourse, policy, lawmaking and implementation, and social behavior. And the panelists will likewise address the health consequences of gendered roles in areas ranging from sex selection policy practices in the U.S. and abroad, hospital breastfeeding laws in the U.S., laws related to honor and women's virtue in the Middle East, and the current U.S. Preoccupation with the ways in which women, and mothers in particular, are perceived as posing risks to their children's health. We have five panelists presenting four pieces of work, and we only have an hour and a half, so I'll keep this introduction short, and I'll apologize in advance that while introducing the panelists, I may not do justice to their accomplishments. And I encourage you all to read their full biographic statements in the conference materials. Our first presenters will be Jennifer Bernstein and Lainie Rutkow, and they'll be discussing hospital breastfeeding laws in the U.S., paternalism, or empowerment. Hospital breastfeeding laws aimed at increasing exclusive breastfeeding of infants are emerging in various places in the U.S., and the laws vary significantly in their structure and effect, and warrant a careful analysis of the ways in which they may have paternalistic or empowering effects. Jennifer Bernstein is a JD and MPH. She's the senior attorney at the Network for Public Health Law, Mid-States Region at the University of Michigan School of Public Health. The Network for Public Health Law provides legal technical assistance, develops resources, and conducts training on a wide range of public health law issues for public health attorneys, public health practitioners, and policymakers. Ms. Bernstein's research interests include women's health, health disparities, public health uses of electronic health information, and big data. Lainie Rutkow is an assistant professor of health policy and management at the Johns Hopkins Bloomberg School of Public Health and the assistant director of the Johns Hopkins Center for Law and the Public's Health. She served as a fellow with the Committee on Government Reform in the U.S. House of Representatives, and she's worked with the Legal Aid Society of New York's Health Law Unit and the New York Civil Liberties Union. Our next presenter will be Linda Fentiman. She'll be discussing her work in progress, a book entitled Blaming Moms. It's about how unconscious gender roles and racial stereotypes and psychosocial processes of risk construction intersect with ostensibly neutral legal principles to promote a legal regime in which mothers are primarily responsible for promoting children's health. Professor Fentiman, she's a professor at Pace University Law School, where she specializes in health law and criminal law. In 2011, she was named the James D. Hopkins Professor in recognition of her excellence in scholarship and teaching. In addition to Pace, she has taught at Columbia and Suffolk University Law Schools, the University of Houston Law Center, and the University of Warsaw in Poland, where she was a Fulbright Scholar. Sital Kalantry will be discussing her paper, Sex Selection in the United States, a Contextualist Feminist Approach. Her work examines U.S. legal initiatives regarding sex selection practices and the ways in which proponents of policy and legislation use examples of sex selection practices in India and China. Professor Kalantry is a clinical professor at the University of Chicago Law School, where she founded and is director of the International Human Rights Clinic. Prior to joining the clinical faculty at the University, maybe a Freudian slip, at the University of Chicago Law School, she was director of the Cornell International Human Rights Clinic and founding faculty director of the Avon Global Center for Women and Justice. Our final presenter will be Tzili Moore, who will be discussing her paper, The Shame and Honor, Feminist Analysis of the Health Consequences of Legal Systems Premised on Notions of Women as Communal Gauges of Honor. Looking at legal provisions and social practices in Morocco and Jordan, she examines the influence of notions of communal honor and critiques piecemeal efforts to change laws detrimental to women's health for their absence of a more comprehensive analysis. Ms. Moore is currently a visiting jurist at UCLA Law School. She worked as a gender and human rights expert implementing law reform and advocacy initiatives in Africa, Asia, Central Asia, and the Middle East. She served with the ABA Rule of Law Initiative in Jordan and Central Asia, and as a gender justice advisor in Afghanistan with the International Development Law Organization, where she worked with the country's first ever special prosecution unit on violence against women. She previously taught as acting director and clinical fellow at Georgetown Law's International Women's Human Rights Clinic. Each presentation will be given about 15 minutes. Two of our presenters need to leave to catch a plane at exactly 12:30, so we'll be attempting to end on time today. And with that, we will begin.
So, good morning. My name is Lainie Rutkow, and my colleague Jennifer Bernstein is going to deliver the bulk of our presentation, but while she's getting set up, I just wanted to give a quick frame for the work that we're going to be discussing, and also an apology. I'm the reason that we need to end at exactly 12:30. And of course, a big thank you to our hosts today, and especially the Center on Applied Feminism. So Jennifer and I are both public health lawyers, and that means that the work that we do comes at the intersection of public health practice and law, and we spend a lot of time examining this fundamental tension that comes up between actions taken by governments, which may or may not promote and protect the public's health, and the ramifications of those actions for individual rights and liberties. And I think that you'll see that theme come up repeatedly in our presentation on breastfeeding policies in the hospital setting. And just one final thought before I turn things over to Jennifer. I really like this paper and this presentation because the original idea for it came out of a technical assistance request that Jennifer received as part of her work with the Network for Public Health Law. So this analysis is actually directly responsive to a real world question. So thank you.
Okay, so in the world of public health law, we love PowerPoints, and we always outline ahead of time. So just to let you know what I'm going to be talking about, we're going to look at breastfeeding in the U.S. generally, and then talking about breastfeeding in the hospital setting. To really understand what these laws do, I think it's important to understand the state of breastfeeding in the U.S. And then we'll look at New York and California laws. These currently are the only two hospital breastfeeding laws in the U.S. They are, I think, quite innovative, but they're structured very differently. So I'll talk about a little bit about the differences and what kind of effects that might have. And then I'll talk about breastfeeding, feminism, and public health and the relation that all three of them have to each other. And finally, I'll close by talking about our view that hospital breastfeeding law is actually increases reproductive choice and the role that public health has to play in that increase, and then some next steps that we see in this work. So, breastfeeding in the U.S. There's very strong scientific evidence that shows the health benefits of breastfeeding to mothers and infants. Lots of literature out there, lots of different health effects, from obesity to chronic, other chronic diseases, infectious disease. There's also economic benefits as well, and a large literature on that. The prevalence of breastfeeding initiation and duration has been increasing nationally over the past few decades, but the rates are still very, very low, and they're very, very low compared to national targets. So there's something, so in 2010, it was 16.4% for exclusive breastfeeding through 6 months. Most organizations, the World Health Organization, the American Academy of Pediatrics, they all recommend 12 months of exclusive breastfeeding with solid food supplementation. So the rate for that is even lower. The national target, the Healthy People 2020, is a federal initiative to set health targets for the country. There are 3 targets that include breastfeeding, and just for exclusive through 6 months, the target is 25.5% by 2020. So obviously there's a very large gap currently between the national rate and the target goal. And also there are a lot of disparities that exist in breastfeeding rates that are based on race, income, education, marital status, and age. So this isn't just a women's issue. It has intersections across different demographics. And so just for an example, 74.6% of all infants were ever breastfed in 2008, but that number for African American infants was only 58.9%. And that number is higher for Hispanic, but still lower for Caucasian than, or in relation to Caucasian infants. And the reasons for these disparities, I'll talk a little bit about in a later slide. So there are a lot of barriers to breastfeeding in the hospital and healthcare settings. Some of these include formula company advertising. A lot of times upon entry or discharge, women will be given what are called goodie bags, and they include free formula, free pacifiers, free coupons for diapers and other things. A lot of people see these as, you know, we're just trying to help new mothers out, but be giving a woman who has the intention to breastfeed a bottle or a can of formula as she leaves the hospital sends the wrong message. And it also encourages women that have a concerted intention to breastfeed to turn to formula rather than seeking other forms of support when she has difficulty with breastfeeding. And so others include lack of clinician education, lack of staff support for breastfeeding, lack of clarity in the reimbursement for breastfeeding support services. The ACA has some provisions, though they're very unclear, and the application of them has varied as to how services and breastfeeding supplies will be reimbursed and supported. And also the inattention to the importance of breastfeeding by health providers. So providers not understanding and communicating to women the benefits of breastfeeding. So clinicians do have a very influential role in breastfeeding initiation and continuation. They act as role models a lot of times to help women understand the importance, and then also to support them in learning breastfeeding. It's not something that necessarily comes natural. It's not intuitive necessarily, and most women need support in breastfeeding to be able to do it successfully. And then evidence-based quality of care practices for breastfeeding has been shown to reduce barriers and increase breastfeeding rates. So these programs are important. One of the, I think, the most well-known and well-researched initiatives is the Baby Friendly Hospital Initiative, which was created in 1991 by the World Health Organization. It's a global evidence-based standard for infant feeding. Within the initiative, it encourages hospitals to adopt the 10 steps to successful breastfeeding. And so that includes written breastfeeding policies, training staff to implement policies, informing patients of the benefit and management of breastfeeding, helping women to initiate breastfeeding within an hour after birth, which is very important, has been shown to be very important for successful breastfeeding, training women how to breastfeed, not giving infants food or other drinks such as water after birth, rooming in, which is allowing infant to be in the room with the mother 24 hours a day unless medically contraindicated, encouraging breastfeeding on demand, so when the infant wants to feed, encouraging that rather than setting up a breastfeeding schedule that's just an arbitrary schedule. Not introducing artificial teats or pacifiers, and fostering the establishment of breastfeeding support groups within the community. So having places to send women who are having difficulty breastfeeding, giving them the support that they need. So the New York law was the first part of this law, New York passed perinatal services regulations in 1988. So this is before the baby-friendly hospital initiative, but a lot of the perinatal regulations actually mirror 1 through 8 of the 10 steps to successful breastfeeding, at least in part. Steps 9 and 10, which is artificial teats or pacifiers and fostering the establishment of breastfeeding support groups, were not reflected in the regulations. And then in 2009, the Breastfeeding Mothers Bill of Rights was passed, and this was really quite innovative. It was designed as an informational law, but the effect of the law has been much more than informational. It specifies 22 enumerated rights that women can exercise during pregnancy, during and after delivery, and after discharge. Most of the rights that are provided in the law are reflected in the perinatal regulation, so it doesn't really create anything new. It does, the bulk of the law doesn't do anything new. It does add those steps 9 and 10 as requirements for hospitals. So it does expand it there, but most of the law is nothing new. It just makes it so the hospital has to distribute pamphlets or literature to women when they do their pre-booking or when upon intake, and it has to post the Bill of Rights in a conspicuous place. And then there's no private right of action, but complaints can be filed with the New York Department of Health. The implementation of the regulations was mostly, it was aimed at increasing awareness of the regulations and evaluating compliance, but it didn't take a very hard line with hospitals. Practice scores were shared between facilities, but it didn't do much to encourage application of the law. Once the Breastfeeding Mothers Bill of Rights were enacted, there were more traditional enforcement methods. In 2009, the New York Department of Health requested hospitals' written policies, and then they sent letters talking about their areas of noncompliance, and they repeated the process in 2011, 2013, and they sent letters saying that they had 12-week period to correct where they were lacking, and otherwise they would take formal enforcement action, even though the law was set up as an informational law. California, they had early legislation in '95 that gave women the right to breastfeeding consultants or provision of information. Doesn't have much effect because provision of information is a very easy bar. It didn't really require hospitals to have breastfeeding consultants. And in 2007, there was a law that provided training courses for hospital staff of the department. Hospital Infant Feeding Act in 2011, it requires all hospitals to have infant feeding policy that draws upon guidance from the Baby Friendly Hospital Initiative or state health department policies, and they're very similar to the 10 steps. It is too early to tell. This law was passed in 2011, I believe, and it just took effect the 1st of this year. It's too early to tell what the implementation will look like, though a lot of hospitals in California, I think it's the state with the highest number of baby-friendly hospitals, certified baby-friendly hospitals in the country. They also have the highest exclusive breastfeeding rate in the country right now. The follow-up law was passed, which requires hospitals to adopt the 10 steps or alternative policies by 2025. So this recognizes that the first law didn't make adoption mandatory, but made it more discretionary to use as guidance. So the New York law versus the California law, the real differences exist in the type of guidance that it provides. So New York is really a broad mandate. It leaves implementation measures largely to the hospital's discretion, whereas California gives very specific guidance and is now going to require actual adoption of that specific guidance by 2025. Some other differences are the provision of breastfeeding information. the standards for breastfeeding consultants, the ability of patients to decline breastfeeding information, and non-English speakers. And I go into more depth in the paper about all these. So public health and paternalism. Public health, the mission of public health is to protect and promote the health of populations. It derives its legal authority from police powers. Most of these laws, it's a state responsibility versus federal, so state police powers. And in public health, there's always a balancing act between population welfare and individual rights. And so public health often gets the charge of being paternalistic. There's arguments against laws that target self-regarding behaviors, so smoking, unhealthy eating, exercise. And the standards for breastfeeding consultants are, I think that is not supposed to be there, sorry. Directly restrictive to consumers is another charge, that they're damaging to commercial interests. And one of the really good examples is the Latch On NYC campaign, which had a large backlash. So you can read these quick. There's some of the comments. And I'm being told I'm out of time, so I guess I'm just going to go to my next steps and say that to create a really truly comprehensive system that protects breastfeeding, hospital breastfeeding laws do a really great job, and we support them. We don't think that they are in conflict with individual rights, and they actually provide greater reproductive choice for women. Before, there used to be one model, and that was formula feeding. Now women have greater choices to decide how they want to feed their children. But to really support breastfeeding, we need to look at a comprehensive legal framework. And so that's going to also be addressing barriers in the childcare setting and eliminating financial barriers to breastfeeding. Thank you.
No. Professor Linda Fentiman will be our next presenter. We just get our PowerPoint up here.
Fabulous. So thank you. Can you hear me in the back? Okay, I'm doing my best Ethel Merman imitation. Okay, so I want to thank Eve, the conference organizers, and the other panelists for a fabulous program. And the talk I'm giving about blaming moms is part of a larger argument I'm making. There's the condensed larger version, which is appearing this spring in the Virginia Journal of Social Policy and the Law, and the much bigger version is in a forthcoming book, Blaming Moms, Mothers, Children, and the Quest for Harm-Free Childhood, which will be published by NYU Press. So I begin with the observation that I made that came to me over the last few years, that over the last 40 years, American society and law have focused increasingly on mothers as a significant source of harm to their children, ignoring fathers, poverty, dangerous social environments, and toxic chemicals. Like French philosopher Elizabeth Badinter, I believe it is not a coincidence that the emphasis on mothers' roles in ensuring their children's health arose just as the feminist movement was taking off and women sought to redefine their roles inside and outside the home. So this, I too, as a lawyer, still do the big picture first. This is what I'm going to talk about. But treating mothers as vectors of risk will not lead to healthier children. Instead, the spotlight on mothers diverts public attention and resources from more serious threats of harm to children, leading to policies which are both misogynistic and misguided. This morning, I will identify multiple ways in which socially and psychologically constructed risk is connected to American law, that American law both reflects these underlying social and psychological processes and then contributes to its reconstruction. and I will demonstrate how unconscious risk construction processes intersect with both substantive law and its implementation on the ground by actors with discretion to make it more likely that mothers and not others are held legally responsible for their children's health. So today, this is the recap. Doctors, government, and the media herald a wide array of risks that mothers pose to children. We've heard them. Pregnant women are often seen as the sole guarantors of fetal health, and widely held normative beliefs about how the good pregnant woman should behave have frequently led to legal interventions. Since 1996, more than a dozen women who have used legal or illegal drugs while pregnant, or even refused to have a C-section, have been charged with and sometimes convicted of murder or attempted murder after they suffered a stillbirth. In other cases, women who have declined recommended medical treatment have been subjected to court-ordered medical interventions, again including C-sections, blood transfusions, and civil commitment for substance abuse. Even accidents have become the fodder for law enforcement. So in 2010, Christine Taylor, a pregnant Iowa woman, was arrested for attempted feticide after she fell down the stairs. Her arrest was triggered by a statement that she made while seeking treatment to make sure that her fetus was okay at a hospital emergency room. She told the staff that she felt ambivalent about this baby since her husband had just abandoned her and their 2 young children. Her confidential conversation was then reported to law enforcement, who arrested and jailed her. Prosecutors ultimately decided not to proceed, but only because she was too early in her pregnancy to come within the terms of the feticide statute. Once children are born, government action directed towards mothers is also common. Breastfeeding is another area in which mothers' actions or inactions have been perceived as risky to their children's health. And I have to disagree with Jennifer and Lainie about the data in terms of the benefits of breastfeeding. I wrote about this in an earlier article, Marketing Mother's Milk. I assert that for American women, breastfeeding is being oversold. It should be a woman's choice, but the government should not be mandating it in any way, because not breastfeeding is not risky. But we have to look at other contributors to children's health. And too often, doctors, government, and the media ignore the multiple ways in which fathers can adversely affect children's health, which I've just listed on the slide. Most importantly, male sexual and physical abuse of children, particularly girls, is a significant factor in their later development of physical and mental health problems and substance abuse. Yet so far, our legal, political, and social systems have taken a hands-off approach, being unable or unwilling to adequately address childhood abuse and adult domestic violence. My point here is not to vilify fathers, but rather to suggest that they are at least as important as mothers in shaping their children's health. Similarly, the government has been slow to protect children from environmental harms, including exposure to toxic chemicals through air pollution and contaminated water, as well as the important latent risks of poverty. Children living in dilapidated housing are exposed to heavy metal and to cockroaches, which are linked to asthma. Children in poor neighborhoods lack safe places to play, access to healthy food, and are exposed to physical danger and psychological stress, all of which lead to poor health. And the recent Institute of Medicine report, Neurons to Neighborhoods, has identified the developmental connections between poverty and poor children's and adults' health. So what's ironic, I think, about the emphasis on mothers' role in promoting children's health is the fact that really American children are quite healthy, relatively speaking. At the start of the 20th century, 1/5 of American children died before their 5th birthday. Even at mid-century, a child's chance of dying from epidemic diseases like polio, pertussis, and diphtheria was very real. But current life expectancy is higher than ever. The average American infant born today will live to age 78. It is because parents now come to expect that their children will live and survive to a healthy adulthood that our perceptions of risk and riskiness have changed. Now, of course, the historical perspective is not the only one, and compared to other developed nations, the U.S. falls woefully short in measures of children's health, particularly in infant mortality and preterm birth. And we know that these differences are largely attributable to persistent racial and economic disparities in healthcare access and the persistent effects of poverty. So I now turn to two inquiries which are related. The first addresses the psychosocial processes of risk construction. How do we perceive risk and how do we talk about it? And the second asks how these processes of risk construction intersect with the law, particularly in determining legal responsibility for children's health. And here, my point, which I'm not going to elaborate upon, is that risk is not a quantifiable fact. Risk is in the eye of the beholder, and there are many psychosocial processes that inform our assessment of risk, including our worldviews. This is the grid for the worldview, and also other unconscious social processes. People tend to view risk as more serious when they've experienced it personally or heard about it from the media. That's the availability heuristic. And there are other psychosocial mechanisms that affect how we decide about risk. When we look at substantive law, we see that it also reflects the worldview of its creators, and then law is implemented on the ground by individual decision makers, again affected by unconscious risk construction processes. And I want to turn to, I'm going to identify, because turning is not possible, 3 areas of the law which affect our current emphasis on mothers as the source of harm to their children. The first is the reasonable person, which is highly elastic. The second is laws, the rules of causation, which are also highly flexible. And third is the emphasis of our legal system on realized harm rather than preventing harm. And all 3 of these aspects of our legal system are connected by the concept of foreseeability. So if we look at the reasonable person, we know that it is the jury that brings to life the standard of the reasonable person. And an example of how this arises is the case of pregnant women. There's a handful of cases, 6 cases, in which born children have sued their mothers, asserting that they were negligent while they were pregnant. 3 of these courts found that the mother should be treated just like any other tortfeasor, while 3 of the courts specifically declined to impose a duty on the mother because of the long-run harmful effects, because of the flexible and elusive standards, and the fact that the jurors would inevitably bring their own biases to deciding in hindsight how a particular pregnant woman should have behaved and how she was negligent. The final area that I want to talk about is causation in tort law. And we all know that actual cause and proximate cause are required. And in terms of proximate cause, we see that everything that a pregnant woman does has potential impacts on her developing fetus's health. And of course, everything that happens could be foreseeable to the pregnant woman. If we look in detail at lead poisoning, we see that lead is a potent neurotoxin. It causes significant harms. And in 2013, the Centers for Disease Control estimated that more than 500,000 American children under age 6, or 1 in 38 children, are victims of lead poisoning, a health crisis that dwarfs the polio epidemics of the mid-20th century, but does not get media attention. Most of these children ingest lead in the form of lead dust or lead paint flakes, which are released when the landlords fail to maintain their apartments in good order. Tort litigation to compensate lead-poisoned children has proceeded along two fronts. First, against the manufacturers of lead paints and pigments, which have been almost universally unsuccessful because courts have refused to adopt a market share liability approach. When individual plaintiffs sue a landlord, the frequent response of the landlord is to push back on the causation issue and to say that it is the mother's fault that the child is suffering neurological and cognitive impairments. It's not the lead paint, says the landlord, and the landlord seeks discovery of the mother's academic records. The mother seeks, in some cases, for the mother to undergo an IQ test to prove that the actual cause of the child's injuries, which sure look like lead poisoning, are really the fault of the mother. So what we could do differently is look at the big picture. We could take systemic actions to protect all American children, focus not on mothers' actions, but instead undertake the precautionary principle and act prophylactically to prevent harm to American children. Thank you very much.
Thank you. Sital Kalantry will present next.
Thank you so much. Really proud to be here. Thankful for the center. Its vision is very much appreciated and in line with how I approach my work, which is, looking at scholarly and interdisciplinary methodologies to impact advocacy work. And I think this project is sort of along the lines of that. What I wanted to start with is to talk about the genesis of the project. So, which has now become this paper that you read, and it's also blossomed into a year-long clinical project, and as well as some other papers I'm doing with economists. So an undergraduate at the University of Chicago approached me and said, "Can you moderate this film? It's a girl, the three deadliest words." And I know it's a great program, so I was just trying to do some research about it. It's about sex selection in India and China. And for those of you who may not be familiar with what's happening in countries like India, which I work quite a bit in, this is a chart that shows how sex ratios are decreasing. So the way it's being talked about in India is in the feminist communities is that it's a problem of sex ratios, not necessarily of the gender side or abortion. We're seeing that ultrasounds were used to identify the sex of the fetus, and female fetuses were aborted, thereby decreasing the number of natural occurrence of females in the population. The normal at-birth ratio expressed in Indian terms is 1,000 boys to 952 girls. Biologically, there's just apparently more boys born than girls because they tend to not survive as long. Yet the overall ratio in India is 1,000 boys to 943 girls, according to the 2011 census. But this varies quite a bit, and what we find, and in the worst cases, in some places now there's about 15 to 20% more men than women. So there's groups of men who will never be able to be married. And this really destabilizes, potentially, society. So going back to the film, I was doing my research on it. Should I moderate this film or not? Ms. Magazine calls it a feminist film. Okay, you know, it's getting its creds. The Now New Jersey chapter is showing this film. Women's groups across the country are. Then I, you know, checked out who is the director. He's this hip guy who's a social justice advocate going around the world making movies. So then I said yes. Then I watched the movie. And I was watching it with audience, and I just was really troubled by it because it's to me what it basically does is puts the anti-abortion lens broadly on the issue rather than an anti-sex selection lens. And I still don't know who is funding this movie because there's nothing written on it, even though it's filmed on location in China and India. So I then went to this website where I can find who owns website addresses, and it turns out that the website is owned by Shadowlines Films, which then is owned by Evan Davis, which then is owned by Harvest Media Ministries. This is the other profile of the director who says, you know, his work, his life's mission is to promote the words of Jesus Christ using, which is also fine, I have no problem with that, but you look at their website, they make anti-choice videos, it's using, you know, media to convince, to have an anti-abortion message. So then how does this migrate to the United States, right? This organization is featured in this film, and people are moved to donate to this organization that's doing great work in China, according to the film. And when you go to their websites, you know, you will say, okay, great, you know, this is a problem in China and India, we need to stop it. So, but it turns out that that organization, I do more research, is actually part of a coalition. You can see down here, Women's Rights Without Frontiers. Oops, I'm sorry. I won't try to use this pointer. Right, so then it's a woman who generally supports reproductive rights in the US, sends its dollars to this organization allegedly working in China, but then they're actually restricting her own reproductive rights in the US unknowingly. So, and this is succeeding, this is an issue. 7 states prohibit sex selection abortion. The first 2 passed in the 80s, but it's Oklahoma, Arizona, and North Dakota, Kansas, and North Carolina that have done it more recently, and 20 plus states have proposed it. There was a bill in Congress called Prenda that's trying to ban sex selection abortion in India, in the United States. So in fact, it's one of the top 3 legislative agendas for the anti-choice movement. I'll just give you a quote from the head of the Population Research Institute, Stephen Mosier, who says, quote, "I propose that we, the pro-life movement, adopt as our next goal the banning of sex-selective abortions. By formally protecting all female fetuses from abortion on the ground of their sex, we would plant in the law the proposition that the developing child is a being whose claims on us should not depend on their sex." So these laws also some of them don't even have an intent requirement. So a doctor who performs an abortion and then later turns out to be for sex selective purposes, even if he didn't or she didn't know it, they are liable. You have to sign an affidavit in Arizona that says, I am not aborting my fetus for its sex to get an abortion. So this legislative push, I then started to read this legislative testimony, the hearings, what are people saying about it, and basically what I'm seeing is this narrative in the testimony. 1, there are millions of women missing around the world, you know, per Amartya Sen and a lot of economists. 2, there's a global shortage of girls because these savages in India and China are aborting their female fetuses. Never mind that this is happening in Azerbaijan, in the Balkans. These are other countries beyond India and China, but India and China are always focused on. And then 3, these Asians come to this country, they bring their sexism with them, and they commit feticide here, and we must stop them. This is sort of how it's being framed, and some lawmakers have specifically said, oh, well, we must, you know, pass these bans just, you know, as a way to sympathize with other countries. Most recently, a couple of weeks ago, South Dakota is most specifically have targeted Asian immigrants. The pro-life committee heads basically said, look, there's 1.1 Asians in South Dakota, according to our census. They're all committing sex selection abortions, and therefore we need to ban it. I'll get to the more empirical evidence at the end about what is actually happening in the U.S. and what we're doing to really examine it. But just briefly, the laws that are being passed don't really address other forms of sex selection. They're not addressing non-abortion sex selection, which is occurring. We don't have any limitations on sperm sorting or PGD, which occurs prior to abortion. And fertility clinics in the U.S. are widely marketing it. I just recently saw a clinic saying, have your sex selection if you want. People here think they're doing it for family balancing purposes. Not everyone, people want to have one boy and one girl, but don't want to have 10 children. So that's kind of how it's perceived in the U.S. Among some people. So the question is that I have is, so why is the anti-choice message gaining traction? Or to put it another way, why are pro-choice organizations not necessarily presenting a compelling counter-narrative? And some hypotheses, one may just be the lack of knowledge about other countries in India, so they can't counter the anti-choice framing put on sex selection. It may be that this lack of knowledge exists because of the universal position taken that sex selection bans. Some pro-choice groups say sex selection bans we oppose in the U.S., we oppose in India, we oppose in China, we oppose in every country. So we don't really need to engage with those realities. It could be that the mainstream pro-choice groups sort of accept the anti-choice framing that sex selection is widespread among Asians, and it occurs because sexist attitudes, and that's what causes it. And so they're sort of at a loss to message against this. It could be because it's really not a priority, right? I mean, Planned Parenthood takes an official position: we will not perform sex selection abortions. So in reality, most women don't have access to it in any event. Or it could be a really a feminist or moral issue, right? So mainstream, I think it's dividing mainstream Americans because equality for women appears on both sides of the equation. On the one hand, one can argue that sex selection should not be permitted because some people may be aborting female fetuses because of a culture of son preference that values boys more than girls. On the other hand, prohibiting sex selection obviously constrains a right to autonomy. So if we start going into reasons for why a woman is having an abortion, then we also have to start thinking about, well, maybe saying it's not a good time, or I have 5 children already, that's also not a good reason. So the way I'm trying to think about it and look at it is to, I think it's really important for us to go globally and look globally, because obviously the anti-abortion movement is doing it. And so I think that it is important, I believe, to value women's autonomy and look and keep that as your priority. But if you look at the context of the situation in some countries, it may be that this autonomy is being used to threaten women's equality as a whole. And some theorists, like Catherine McKinnon, for example, has said, well, their justification for let's not ban it in the U.S., but let's ban it in India because, well, the women in India can't even exercise their right to choice anyway because they're so duped by patriarchy. I think this view is problematic because it denies women's agency in an attempt to preserve autonomy rights for other women. And instead, what's appealing, and some are considering, some feminists like Nivedita Menon has started to articulate this concept of equality, as well as April Sherry, who's an American feminist, to look at, let's look at how sex selection is impacting equality. I just sort of start to think about how we might assess equality. Does sex selection reflect inequality? Does it perpetuate inequality? And I'm going to sort of speed up because I know I'm running short on time. And in the paper, I don't really sort of apply this to the countries, but some of the ways here I do thinking about that. So in India, yes, the birth ratio is screwed, so it maybe does reflect some inequality. In the U.S., our ratio is completely not skewed in any way, and to the extent it's occurring, it might be for family balancing purposes. A group of studies have come out in India. Some people are suggesting trafficking is increasing because of it. So brides are being imported from Nepal, and trafficking is also problematic in for a lot of host of reasons. Domestic violence might be increasing, so men are worried that their women are going to go out and get raped, and stranger violence might be increasing. So it might actually be perpetuating inequality. Next steps for us is we had it's a year-long project. We had a student and my clinical fellow go to India in December to look at the complexities and understand why it is happening in India so that we can reframe the reality and also distinguish it from the United States. We also have two economists who are working with us to look at the most recent 2010 census data in the U.S. to see the only way, we have no idea what people do. So what people make assumptions from is sex ratios, that sex selection is occurring. So this data that they're looking at, this chart is basically the entire, this is from a 2008 study by two economists, and all of the laws that are being passed in the U.S. rely on this chart. This shows that three groups of people, Asians, Chinese, and Koreans who are foreign-born, looks like when they have two girls, they have a disproportionate number of boys as their third children. So it's this, basically, this delta is what is causing the U.S. to pass all kinds of laws. And when we look at the 2010 census, we found that this data, this is what we're talking about, is 174 girls. So maybe in the U.S. every year we potentially, if we think that this is because of abortion, we have 174 missing girls, and this is our cause for statewide and national legislation. And we also are finding now in latest data that we're looking at that in the first two children, they're actually having more girls than white Americans. So cumulatively, if you add up the number 1, number 2, number 3 children, it may be that there's actually, quote unquote, no girls missing. We're also finding assimilation effects. So once, this looks only at foreign born. When we look at Asians born in this country, there's absolutely no sex ratio gap. So the answer, is give people green cards, don't stop abortions. Right? Yeah, sounds good. So, and then we studied the impact of the Illinois and Pennsylvania ban, because that's been in place since the 80s. And so we have this great ability to look at data from before the ban and after the ban. And we found no changes in sex ratios. So in Illinois, it was never a problem in terms of sex ratio imbalances between Asians and whites. In Pennsylvania, there was a sex ratio gap in these sort of very minor, right? And that it didn't change, the ban didn't stop it in any particular way or impact it. So we're hoping that this project will really, we're working with the organization that's really leading the charge, the National Organization for Asian American Pacific Women. We're working with them to hopefully reframe and launch a report that changes some of this conversation in the US. Thank you. What? Yeah, let's switch places.
Our next panelist, our last panelist is Tzili Moore.
Good morning, afternoon almost. Thank you so much for this opportunity. It's been really fascinating to sit through today and listening also to the morning session about morality and gender and how that plays out here, because what I'm about to talk to you about is very much a morality, gender, sexuality kind of paradigm, but also very much related to sort of these issues of stigma and shame that come from not acting in sort of a gender appropriate way in here or anywhere else in the world. And I put the slide up behind us really just to kind of show us a little bit of irony how this is a Pew Global Attitude survey from 2010. You can see in the US people think that most changes for women's equality are not yet done. Like, we still have a lot of work to do, but if you go 9 down to Jordan, which will be the country I'll be focusing on, you'll see that people think that most changes are done, that they really are on the way to equality. And there may be some thought that that is the case. And I picked Jordan not just because I worked there for the past year, but also because it is seen as sort of a modern state. It's primarily urban. Girls and women now make up the majority of college students. I think that's the same in the US. At the same time, there is sort of a development paradox where while women are very highly educated and are more educated than men now, it's a very low ratio of women's participation in the formal work market. There's very high employment for women as opposed to men. And what I wanted to really look at this morning is to highlight how in systems that are really based on looking at very gendered roles for people, particularly for women, how we really need to look beyond very specific kinds of calls of action that say, let's repeal this particular provision of that particular provision, and look more systematically and really look at a host of health consequences of maintaining these kinds of systems that can both justify and lead to systemic gender-based violence. And if some of you may recall, in Morocco a couple of years ago, a girl was raped and was forced to marry her rapist because in the law, if you marry a rapist, that rapist then has no legal consequences against him, and she committed suicide. So there was, global outcry about it, and actually Morocco in January, just a couple of months ago, changed that law, but they only changed that provision. That provision still exists in Jordan. And I'm going to talk about really the host of different provisions that address women as gauges of honor. And I just wanted to really be clear that this is not about a particular religion or a particular country, but really how there's this intersection of socio-legal gender constructs. In the midst of it, we have this policing of women and their roles in society. So I just wanted to very quickly show you this idea of crimes of passion, which we have in the U.S., right? If you get home and you catch your wife in bed with another man and you get really angry and in a fit of passion you kill her and her lover, or the other way around, you come home, your husband is in bed with another woman, that's never pleasant, and you kill them and their lover, that sort of is the crime of passion. And there will probably be, depending on the state, you're in some sort of reduced mitigating circumstances discussion around sort of this fit of rage action. And a crime of honor scenario, it's a bit different. It's still the same for the woman, and I'm focusing on Jordan, okay? It's still the same for the woman. If she comes home, she catches her husband with another woman who is not one of his other 4 wives, she can kill her and him and get some sort of reduced mitigating circumstances. But for the man, it's different. For the man, it's not just the wife and her lover. It's also could be his descendants, so his daughter or the daughter of his daughter, his granddaughter. It could be his sisters. It could be his ascendants, or it could be his mother, and often it could go on to an aunt, the children of the aunt. So for a man in that kind of context, they actually have to be really vigilant of the behavior, not just of their wives and themselves, but the behavior of all these other women, because they will need to act to preserve the honor of a family if any one of them strays. So what are these sort of, and of course the other wives and their families are also included. So I wanted to just pause for a second and talk about what are these sort of crimes of honor I'm thinking about, or using sort of a shorthand. And of course using crimes of honor is very charged. The term itself is very problematic because we're sort of saying, oh yes, it's for honor, so of course we need to do that. But really it's a shorthand for a range of crimes nearly exclusively against women, and they're publicly justified as required to preserve this concept of honor that is usually vested in male control over women, particularly their sexual conduct. And it doesn't have to be actual sexual conduct. It could be suspected. It could be potential, etc. And the range of crimes result obviously from the killing itself in the most extreme form, but it could also be assault, it could be confinement, it could be interference with choice of marriage. So it's wider than just what we see as sort of, the actual killing. Now, the range of these dishonorable acts has expanded over time, which shows you that it's not something fixed, right? So today, it could also mean if you choose to marry outside of your religion, if you choose to marry for love and your family doesn't like who you selected as a partner, and if you're suspected of having any kind of same-sex or other kind of gender identity orientations, that could be a reason as well. And usually these crimes benefit from either a complete exemption, or in Jordan after 2001 when the law was reformed, just from a reduction in punishment. So it used to be 6 months, and now it's actually increasing, and some courts are giving 10-year sentences for killing. So there is some movement, but I'm going to talk about how there are some still particular issues. So human rights bodies, the UN and international community, have been looking at this issue, and since 2000, both the General Assembly has issued resolutions saying this is a problem. There are at least 4 different special rapporteurs that have looked at it. It's been termed a form of extrajudicial killing. When it's an actual killing, it's been termed obviously a form of gender-based violence and as a harmful traditional practice. But the analysis, as I will sort of show, has been very siloed, but and not looked at in the constellation of different laws that make this possible. So if you recall the story about the girl who was raped in Morocco, similarly in Jordan, right? If a girl is raped there, what are her options? Extramarital and any sex outside of a marriage is criminalized. So courting is criminalized in a way. So if you are either by choice or by force engaged in some sort of sexual conduct and you're pregnant, these are your choices. Abortion is illegal, particularly if, well, not particularly, but including for rape or incest, which is also another issue. But the law inextricably has a provision in the criminal law under abortion that if you are pregnant and you want to induce your own abortion to preserve your honor, that's the word used in the law, you will actually benefit from a mitigating circumstance. But not if you go to any kind of medical professional. They will not benefit from any kind of mitigating circumstance. So if you and a relative induce some sort of unsafe abortion and survive that abortion, you might actually benefit from a mitigating circumstance. The law that deals with the mitigating circumstances for these so-called honor killings does not actually use the word honor in the provisions. The two provisions that judges have been relying on, one of them just talks about if a man catches any of these female relatives in a questionable sexual position, he injures or kills them, he will benefit from reduced circumstances. Not a woman, but a man. It doesn't say because he's doing it for honor, because the provision in itself sort of captures the social imagination of what that would be. And the other provision that judges have tended to rely on is really just a general mitigating circumstances kind of provision, like a fit of rage kind of mitigating circumstance. So they don't actually use the word honor, but that is the term that's used. The other option that you have if you're raped and pregnant is to marry a rapist. And that is a big incentive, for the rapist, because then he does not have to face any charges. You have to remain married for 5 years for that to stick. So some activists have been really calling it, this is the article that allows for it in the Jordanian code is Article 308. And here, what the wording say, the Article 308 basically forces multiple forms of rape on a victim, right? Not only was she raped, but now she has to be married to this person for at least 5 years. And there is no marital rape, of course, protection. So she could be continually raped within the marriage. So that's her other option, which often is the default option for many women. There really is no possibility of her living on her own and raising a child out of wedlock. If you give birth to a child out of wedlock, they're still considered illegitimate children, and they will be taken away from the hospital and be raised in an institution. And it's nearly impossible for you to reclaim your baby if you still want to raise that child. And of course, that child will face a life of discrimination and disadvantage because they are considered these illegitimate, non-existent children. The other option, of course, is you could be killed by your family to preserve the honor. Or the state could protect you by putting you under protective custody, where you could be for a really long time, and there are documented cases of women being in so-called protective custody in prison, in the women's prison. That's protective custody for 8 and 10 years. So in Jordan, the tension between these laws that sort of tend to overprotect women, they're not allowed to work in certain professions, and at the same time sort of underprotect them and fail them, we have this system of extreme vigilant policing. And I'm just going to put this poster up, not because it means anything, but just, it was for election, and it says, women from the field to the parliament, but just to have the men gaze at the women, which I thought was kind of interesting, because here we have these 5 groups that I kind of categorized as having to preserve the system, right? So there's obviously the health consequences for the women themselves if they survive, whether it's the physical, sexual, psychological, mental health, the pregnancy from the rape, having to marry a rapist, the unsafe abortion risk, the so-called illegitimate child, obviously increased rates of suicides, And of course the custody or the incarceration and the added stress and anxiety of being incarcerated, and then of course the stigma of it. But then there's the other women in the community who have not just to police themselves, but to police each other all the time. And this sort of constant psychological terror reminded me of what Bron Miller used to say about the threat of rape, right? It's a way to really keep all women in a state of fear all the time. And it's a similar situation here because there's a threat of an honor killing, and the other legal provisions that really don't give you other options. And of course, reduced likelihood for seeking redress for sexual violence because sex is criminalized unless it's within marriage. So if you come forward to say that something was done to you sexually, you will very quickly become the offender rather than the victim. And then there is those men who commit these crimes. And in Jordan, that is the younger brother. Okay, so in the U.S., most women, or the bulk of women who are killed in these kinds of situations are killed by an intimate partner. Here, it's the younger brother. And the psychological toll of someone who has to now kill this beloved sister or cousin or aunt, and otherwise their masculinity is compromised. And I'm just, a quick quote from the Chief Justice of the High Criminal Court in Jordan, who said, nobody can really want a man. Nobody can really want to kill his wife or daughter or his sister, but sometimes circumstances force him to do it. Sometimes it's society that forces him to do it because people won't forget. Sometimes there are two victims, the murdered and the murderer. And there are real costs to having your family's honor tarnished. People may not want to marry the other sisters. They may not want to do business with your family. They will always know that there was someone in your family who is tarnished, and that will have intergenerational effect. There, of course, the other group is the lovers themselves, right? Not only could they be subject to violence, but now they're grieving possibly the loss of their companion. And then generally the community as a whole, right? The kind of both physical but psychological toll that is required to keep this kind of system in place, these kind of systems of control, the mental cost of rationalizing, resorting to aggression as a form of conflict resolution, and the justification and acceptance of violence based on stepping out of your gender role or stereotype. And in a recent survey of NGOs in Jordan, 90% of parents said girls' honor, preserving the girls' honor is the most important thing for us because that to us signifies the family's honor. So there's still a real belief in that, and the legal system justifies that, right? It basically gives non-state actors the green light to enforce these kinds of actions. So what I'm hoping, and it's a bit of a critique of my work also with feminist groups in Jordan, is that we really have to do these things of sort of reorienting the discourse around law reform that deals with these kinds of issues. First, we really need to look at these health consequences, and there really have been no studies that look at what are the health impacts of a woman who has to marry her rapist and the impact on her, the children, the family, right? What is the impact of having to live sort of in this terror of any kind of transgression? You talking to a male student could really upset your cousin who might see you on campus, and there's majority women on campus. So inevitably in their co-ed classes, inevitably you'll talk to a male student. So really looking at sort of the health consequences, taking it a little bit away from the siloed analysis as equality only. And then of course, not just calling for the repeal of a provision, but looking at it holistically and comprehensively, understanding that women have these multiple identities. They're not just a woman, but they're part of a particular clan or tribe or religion and a context in a country and a community. And the real need to dismantle these kinds of power dynamics, because without doing that, we're not going to have, lasting change, which as one feminist was talking about in Jordan, she said, this generation, women think, the mothers think of honor killings. The next generation, we would like the girls to think of reproductive justice when it comes to these issues. And I think that kind of brings us full circle to, reproductive justice is something that is not just a preoccupation here in the US, but it actually affects women worldwide. Thank you.
Thank you. Okay, well, thank you, everyone. We have about 15 minutes for questions.
I thank you so much, all of you, for your thought-provoking presentations. My question was about the breastfeeding article and also what Professor Fentiman said about choice between formula and breastfeeding. And I was wondering, do you think, is it possible, and I'm sorry if I'm misunderstanding either the presentation or the research behind it, but is it possible in pushing, or not pushing, but advocating this sort of breastfeeding as the only way to go, that it demonizes women that are incapable of producing enough milk and makes them feel less than as mothers or women?
So I didn't get to all of my slides, and I did have a section where I talked about the divide that currently exists within feminism on this issue. There are some women that see breastfeeding advocates as overzealous and that it's creating what's being termed mother guilt. So the way that these laws are structured, they don't require women to breastfeed. They simply require hospitals to provide women with the tools if they choose to do so. So most hospitals, you can't room in with your baby. You can't breastfeed on demand. In a lot of instances, hospitals will give your baby formula before you have the chance to breastfeed or without your consent. These laws are just set up to provide women with more choice in what they're doing, their infant feeding. So I think that also, research shows that I think it's 87% of women have the intent to breastfeed. Most women want to breastfeed. It's that they are not provided with the tools to do so and the ways to be successful. And that starts, it's a spectrum, as I said. We need a comprehensive legal framework but it starts at the hospital. And so, women who aren't able to breastfeed within the first hour usually will not be successful with exclusive breastfeeding through 6 months.
I just wanted to quickly add first, thank you for your question. And Professor Fentiman, thank you for your comment. I think both because it makes for a more interesting panel discussion. And also, I thought about what you said, and it made me get in touch with some of my earliest kind of public health training, which is that, so I think this is one we're going to just agree to disagree. But the science behind it, and we cite about I would say 30 or so studies in our paper, but there are hundreds out there that show that while there may be, as you suggested, no harm from formula feeding, there certainly is lack of benefit conferred from choosing not to breastfeed, and that goes across the lifespan, starting with improved childhood immunity all the way up. Now we're seeing studies that show a potential protective effect against obesity later in life for babies who are breastfed. So that's one thing. But the second thing, and this was the thing that that your comment really made me think about, is that one of the things that public health folks are always trying to do is to make the healthier choice the default choice or the easiest choice. And that's really what these hospital breastfeeding policies do. So they don't say that you can't use formula, but they do say that the healthier choice, which is to breastfeed, is going to be the easier one. However, no one will be prevented from formula feeding if that's what they choose to do.
So I would just say, I think the evidence is much more equivocal, that a lot of the studies don't have these enormous impacts of breastfeeding. And a number of pro-breastfeeding researchers even admit that the women who choose to breastfeed have many other attributes that may lead to other positive health outcomes for their infants and children, but that you can't separate out the fact that a mother who's willing to exclusively breastfeed for the first 6 months may have other psychosocial and economic attributes that make this choice possible for her. The other bigger picture, of course, is that there's so many laws. Until the Affordable Care Act was enacted, there were no legal protections for breastfeeding. Even states that have laws that you are allowed to breastfeed in a public place Often they're not enforced. Although the Pregnancy Discrimination Act protects pregnant women, it doesn't protect breastfeeding women, and breastfeeding is not a medical disability, so you're not protected by the ADA, and you're not capable of exercising the Family and Medical Leave Act in little increments to breastfeed. So there's many, many legal obstacles to breastfeeding, and I think it's important to empower women to make their own choices.
I agree that it's important to empower women, but I totally disagree with your characterization that there was no legislation prior to the Affordable Care Act to protect women in breastfeeding. I think that at the state level, there are a lot of states that have very comprehensive laws. California is a very good example. There's a lot of others across the country. New York and California have been quite exemplary in this area, but there's other states as well. And looking at in the workplace, in the hospital setting, in public, that there does exist. It's just not consistent across states.
We'll leave it there.
Other questions for the panel?
Hi, thank you all for being here. This is a really interesting panel. I actually have a question for Tzili about Jordan and what the feminist organizations in Jordan, like what are the strategies they're using to try to overturn this legislation, or are they trying to just bring awareness about it? Just general strategies they're using.
Excuse me. Well, I think one of the criticisms in my paper is that the campaigns to date have really just focused on repealing isolated provisions. So just repeal 308 or just repeal, that particular provision that's been associated with honor killings, and not any kind of campaign or analysis that connects the dots about how this in totality is the problem. And the largest umbrella women's rights group in the country, what it does annually is issue to the new parliament, because there is a parliament almost every year, issues a 22-page document of just bullet points of, repeal Article X, repeal Article Y, but they're not connecting it for the lawmakers, right? So one of my ending points was that there really needs to be this kind of both comprehensive request and analysis with the lawmakers, both to educate them and the public about both the health and human rights consequences of having a system like that, as opposed to just, eliminating specific isolated provisions.
This is a question problem in the United States.
Right.
Pro-life advocates, their stories are very resistant to facts, right? And we see how, and they also have been very clever in sort of co-opting feminism for their own purposes. No. So I guess that you can rely on facts. And I think you have, since it seems so contextual, right? Because the problem elsewhere. So you can't have the same kind of universal story you might have otherwise. So.
Yeah, I mean, I think that's, I agree with you. I think you've sort of framed it correctly. I think that, yes, to the extent no one's willing to look at facts, it doesn't matter. I was next to a plane with a representative from my state, and I was talking about this to him, and he said, well, that's great that you're looking at data. That's great that you're trying to expose the myths and realities, but they don't care. This is just about limitations on abortion and ways to do that. So the question, though, is to me that there's a group of people who I think are being convinced by these misframing this. So I'm trying to untangle it from, equality here, and I think it could be untangled. What you say is, so is it a feminist, and to let people think about whether or not it's about women's equality in the U.S. and try to frame it from equality perspective, but to show that how it's different. I think the comparative perspective adds a lot. So if there's widespread abortions or whatever, sex selection in India, and there isn't here, and it occurs for child 1, child 2, child 3, it's a devastating public policy situation. So having that frame, and it's not just about violence, and the people here who are here aren't doing it in this way or aren't doing it in a different way. So really I want to attack that narrative of, citing to the global pandemic and making us feel like we're part of that global pandemic. So saying A, we're not. B, to say that when people who come to the U.S., first of all, when they're practicing it there, it's such a different, to show the reality of it, which is it's individual choices in a country where it's expensive to have girls. They don't support the girls go away. The boys support the family. There's no nursing care, so it's the boys that are giving the money. Here, the situation is so different, and it's showing that when it is happening here, it's for different reasons. So I mean, I think that the data would help, and I think reframing the data. The fact is that when you look at that ratio and that line, and you think, wow, this is huge, this is such a problem here, but then you look at the number, well, we're talking potentially about 100 or so people. So to the extent there's middle-of-the-road people who are getting convinced by the wrong data, I think it's those middle-of-the-road people that we would really appeal to, the middle-of-the-road voters who don't, who are watching It's a Girl and restricting their own reproductive rights. I think data and reality could actually influence those people.
Okay, I believe we have time for one more question. I know we have panelists who need to leave at 12:30. I don't want to keep them any longer and have anyone miss a plane. So I want to thank the panelists for such thought-provoking and excellent presentations and a discussion. And there's a lunch upstairs on the 12th floor at 12:30. So it's a good idea to go right up there if you're heading up for lunch. Thanks.